American judges should not be prevented from considering Sharia, or any foreign law for that matter, in deciding their cases. That has been the law of the land for the past 100 years. Since the Supreme Court decision in Hilton versus Hoyat, U.S. courts have been considering foreign law on a regular basis. We live in a global environment. We become a global village. Marriages and commercial transactions are crossing borders, so courts are regularly required to take this into account. As it pertains to this movement, so-called movement, anti-sharia movement, adopting legislation around the country seeking to prevent judges from considering foreign law or sharia, that is on its face unconstitutional. It violates the Supremacy Clause. It violates and implicates the freedom of religion and exercise of Muslim Americans, and is inconsistent with 100 years of jurisprudence. Now, the main point is that how does Sharia actually come into play in an American court setting? I mean, it only comes into play in two circumstances. Either it comes into play as a foreign law, which would mean that Sharia is either a source or a primary source of law in this foreign country, or it's going to come into play as extrinsic evidence to help explain something to a judge. In other words, to explain an ambiguity, to clarify a mistake, to place a context on the expectations of the parties at the time of executing a document, or their understanding of the circumstances surrounding a contract. So it only comes into play in those two limited circumstances. And the jurisprudence is so clear throughout the United States, is that we only would recognize a foreign judgment from a foreign country, or consider foreign law in a U.S. court, only if it comports with our due process and our public policy. In other words, if the decision that was rendered in a foreign country did not provide due process, that did not have an impartial tribunal, that the parties were not able to participate freely in the litigation, and that the court did not have jurisdiction, or that anything the court did would violate our public policy, of course, a U.S. court would not recognize that. And you'll see case after case throughout the United States where these cases are fact-specific. The facts determine the outcome of the case. If the judge finds it did not violate public policy, he will recognize it. If he finds that it violated public policy, he would set it aside. So this is the circumstances that the jurisprudence is clear, that our constitutional protections are already in place. So these additional legislations around the country do not provide any added level of protection for Americans. In fact, they get in no way of implicate constitutional issues such as freedom of religion and the right to contract. So this is really the crux of what the law is. Now, as an example, there's one example that has been used continuously by the proponents of this legislation, which is a New Jersey case, which really is not a case about Sharia. It's a case about a judge failing to comply with New Jersey law. There was an allegation from a wife that her husband was domestically abusing her. He was having unconsensual sexual relations. So during a court proceeding where the wife sought a restraining order, the husband alleged that under his religious beliefs, he believed genuinely that he was entitled to engage in sexual relations with his wife upon demand. And the court decided that there was, it seemed, a genuine belief in that, which impacted whether the defendant formed the intent to commit the crime. Well, of course, the judge mistook an interpretation of New Jersey law. On appeal, the court reversed, saying that there is no necessity for an element of intent. There was a knowing knowledge of the husband that he was engaging in unconsensual sexual relations. Therefore, the court reversed and entered a restraining order. Our system works. The judges in this country are equipped with the tools to review the cases on their facts. And only on their facts would they make these final determinations. So in the end, this allegation that Sharia is coming to supplant our Constitution is intent with nothing but political consequences. It is premised on targeting a particular religious community and marginalizing a religious community. And it is clear because the statutes are specifically drafted to target the Muslim community. And this will cause disharmony in our society. It would cause civil rights violations in our society. And it's going to fuel the Islamophobia and the misinformation.